think at this stage, before we go to the minutes of the meeting, I'd like to introduce, obviously, Mr. Livingston from the Planning Committee, who's obviously here concerning one of the items on the agenda. Minutes of the meeting held on the 15th of June 2021. I move that the minutes of the meeting held on the 15th of June be approved and signed as a correct record. Could I have a seconder, please?
I'll second that.
Thank you, Councillor Hart. Unless there are any objections, I will take them as agreed. Thank you. Item agenda 4, planning protocol changes. I'll now invite Estelle, Director of Law and Democracy, to present the report.
Thank you, Chair. I think it might be appropriate, actually, if I call on Ian. Is that all right? Ian sort of authored the report, and he knows all the details, and he can explain it probably better than me. Is that all right?
Thanks, Estelle, and thanks, Chairman. So the report outlines a change to the Council's constitution, specifically in relation to when applications are reported to Planning Committee, and outlining what applications are dealt with under delegated authority. The change that's been put forward is to resolve an ambiguity or a gap within the Constitution as it's currently in place, that effectively meant that on land that the council owned, an application could be submitted by a third party, not the council, and that application wouldn't automatically have to be reported to Planning Committee. It could be dealt with under delegated authority. The change has come about following a judicial review decision, which is outlined in the report. I believe it's at, it should be 1.3, but it says 1.2, but it's the second 1.2 in the report, which was the outcome of that judicial review resulted in the planning permission in question being quashed, because in that instance there was a perception of bias that was created as a result of the decision being issued under delegated authority due to various links from the developer to a company that the council is a party of. And even though, strictly speaking, the wording of the Constitution had not been breached, the perception of bias was in existence, and therefore the decision was quashed on that basis. The proposed change is to resolve and remove that ambiguity and to make sure that it is as clear and transparent as possible, that any application that's submitted for planning permission or consent under the planning legislation on land that the council owns, or indeed on land that a company to which the council is a party to owns, then that application will automatically be reported to Planning Committee. Thank you, Chair.
Thank you, Chair. So you're simply agreeing to amend a small bit of wording in the planning protocol to require all planning applications and applications under planning legislation to be reported to the Council's Planning Committee if Thanet District Council owns the land to which the application relates, or if a company which the Council is a party to owns the land to which the application relates. And if I can just be clear, Chair, that this it won't apply if there's a planning application on land that has historically been owned by the council but has since been sold off by somebody else, because we can't have a situation where planning officers have to do a title register search to find out who historically has owned the land, just in case we may have owned it. So it's simply to do with current ownership issues, or where a company is involved of which the council may be a party. I can't imagine there'd be many situations like that, apart from the specific situation which was the subject of the JR, which was to do with a company called East Kent Opportunities, which is a partnership between Thanet and KCC. So I can't think of any other situation where that might arise, but Mr. Livingstone is correct in that the current wording in the protocol is very brief, and it is open to some misinterpretation. And as the judge said in the JR, he emphasised that there wasn't bias. He didn't think there was bias, but the interpretation was open to a perception of bias. So this simply aims to resolve that issue and provide absolute clarity, as Mr. Livingston has said. So that's the recommendation set out in the paragraph, marked recommendations, and that's what we're asking you to agree to. And if you agree, then we will, in fact, we've got a standards committee on the 25th, Katie, have we? I might be able to whiz off a quick report so that if you agree this, we can put that to standards then. Hopefully they will approve it. It can go on to council in December and we can get this sorted and the constitution changed. So that's what we're hoping to do. Thanks very much.
Does any member wish to make any comment?
Just a quick question, please. You say land. Does that include buildings also? Because obviously you could potentially own a building on someone else's land. Lease it, for example.
Yes, I think it would apply to buildings and land. Yeah.
Yeah, and the other question, obviously, is that does that cover if it's a mile amendment to a listed building or conservation area? And the other one is where we get an extra bunch because we own the land, as in Shottendale. Does that cover that as well? So if that has that then got to go, always got to come to committee.
So in the answer to the first question, it's any application under planning legislation. So that would include minor material amendments, changes to a listed building, anything that requires consent under the Planning Act 1990. In terms of the specific question with regards to Shottendale, as Estelle outlined, that's land that we don't historically own. We historically owned, but we don't own now. In the specific instance of the agreement previously in place, which came to light during the application being reported to Planning Committee, what we would look to do in those sorts of situations, if they arose during an application, is we would likely just defer to the Planning Committee and bring it to Planning Committee in those sorts of situations. But they are, as Estelle's outlined, we don't automatically check the historic ownership of a site because it's not a material planning consideration. And indeed, in that instance, we flagged out with members because it was considered to be appropriate, given this information had come to light, to just raise it as a point, but it's not something that's it's not a planning consideration in the determination by Planning Committee.
Does anybody else wish to make any comment? Fine. Do members wish to make any recommendations to the Standards Committee? Just the recommendation that's already in the report? Yeah. Can I have a proposer, please? Councillor Hopkinson, yeah. Thank you. And a seconder? Members agree? Right, brilliant. In that case, we'll move on to agenda item 5. And I call upon Estelle to present the report.
Thanks very much, Chair. So this is a very straightforward issue. It's about the mandatory training which we provide to members of the Planning Committee and, in fact, members of the Licensing Board, where it's set out in Article 8 of the Constitution. So I think we introduced mandatory training in 2019, I think it says. So far we've been doing it twice a year. It's quite a burden on officers and a bit of a pressure on members as well. So the proposal is to move the requirement to do the mandatory training once a year, at least once a year. And as the report sets out, that doesn't mean that there won't be any more training throughout the year. And in fact, Ian and his team are very good about bringing forward training to planning as and when new developments happen and there's new legislation or important things that people need to know. But it just means that the mandatory training for both planning and licensing would only be set for once a year. So that's the proposal, simply.
Thank you very much, Estelle. Members can agree the amendments to the Article 8 with any amendments as they consider necessary, or members could reject the amendments. Does any member wish to make any comment? No? Do members wish to propose the recommendation on the report? Could I have a proposer and a seconder?
Happy to propose it.